Okay, well, it looks like it's 12:30, so I'm going to get started. I want to welcome everyone for joining us today. Today's presentation is on the MIG. It's part of a series of webinars being run by Strigberger Brown Armstrong throughout 2021. For those of you who don't know, SBA is a boutique civil litigation firm that was first established in 2018. We have offices in Toronto, Waterloo, and London, although we've primarily all been working remotely now for about a year. And our lawyers handle a wide range of litigation files, including files to do with the SABs, tort, and CGL, amongst other things. For those of you who don't know me, my name is Julianne Brimfield. I am originally from Australia, hence the accent, but I've been in Canada now for 10 years. I've been practicing since 2014 and have been with SBA since it started up in 2018, and I joined the partnership in early 2020. My practice primarily focuses on AB, including fraud investigations and priority loss transfer disputes, and I've successfully defended numerous MIG disputes at the LAT. I also do some tort and coverage type work, and outside of work, I'm an avid ultimate frisbee player when we're not all stuck inside because of a pandemic. Now I'm going to pass it over to my colleague Sonia so she can introduce herself to you all.
Hi, everyone. My name is Sonia Reed, and I don't know most of you because I have about 1 month left as an articling student at SBA, after which I'm very happy to say that I will be joining the firm as SBA's newest associate, which I'm really looking forward to. I also summered with SBA last year, so between that and my articles, I've had exposure to a pretty broad variety of insurance defense matters, but that has included a good amount of accident benefits work, particularly on MIG files, doing mostly opinions, but also some submissions to the LAT. And I'm really looking forward to carrying some of my own accident benefits files in the near future. Outside of work, in the before times, I was a pretty avid yogi and an occasional runner, and I'm also looking forward to getting back into the yoga studio once this is all cleared up, and back into the office. So thanks for tuning in, and without further ado, I'll pass it over to Julianne so we can get started on our discussion of what's going on at the LAT these days.
And just before we start, I just want to mention a couple of housekeeping things. We have slides today. There are a lot of cases discussed, but you don't need to write everything down. As long as you write down our emails, which are before you write now, you can send us an email afterwards. We're happy to send the slides to anyone who wants them. And we're hoping to have a few minutes at the end for questions. So if you do have questions, there's a Q&A box on the screen, hopefully, that you can put your question in and we'll do our best to answer them. Otherwise, you can send us an email with any questions. And if we don't get to certain questions, we can try and respond by email. So without further ado, I just want to talk about some statistics that are coming out from the LAT. So as you can see on this slide, there's been over 200 MIG decisions released in 2020 by the LAT. About 84% of people remained in the MIG and 16% escaped the MIG. There's also some statistics that were released in November 2020 about turnaround time at the LAT. They're actually from the first quarter of 2020, so I'm not really sure how the pandemic has affected these, but as you can see, they're averaging 173 days between the hearing and the decision. So that's about 6 months, which I think is pretty on trend with what I've seen. I've had a couple of MIG decisions turned around in about 3 months, but that seems to be sort of unusual. It's more the norm to be about 6 months. But it's also averaging 505 days between the filing of the application and getting a decision. So it's a pretty lengthy process of more than a year at this point. And that average has actually been increasing steadily since 2017. And I'm not really sure what the LAT is working on to fix that statistic, but I guess we'll see. So how do people escape the MIG? Today, we're going to be talking about the first three, so psychological impairment, chronic pain, and a concussion or a head injury. The other ones you probably all know, broken bones is one of the most obvious ways to escape the MIG. Pre-existing conditions that prevent recovery within the MIG. Now, this we see very rarely at the LAT, so we're not covering it today. And there's also a bit of a question out there whether that actually removes someone from the MIG or if it just makes them not subject to the $3,500 MIG monetary limit and they're not entitled to attendant care. Insufficient notice is sort of a hot topic that's been around for a couple of years. So I just wanted to briefly touch on it before we move on. So everyone knows the case of Augustin and Unifund, which basically established what you had to put in a notice letter when you were denying an OCF 18 on the basis of the MIG. Well, this new decision came out in 2019. It's Headley and Aviva. And while it wasn't actually dealing with the MIG itself, it was dealing with denials of treatment plans. And it essentially established that you have to provide meaningful reasons for denial and you can't use boilerplate statements. So when we used to just say, it's denied because we believe you're in the MIG, I think that would constitute a boilerplate statement. So you need to say why you believe they're in the MIG. So it's always good to reference whatever medical documents you have, as well as the OCF 18 if that's all you have, or an OCF 3 if that's all you have. So as long as you're referencing what's in the file, I think you'll meet the requirements in Headley. But luckily, the Divisional Court has also confirmed in the decision of Zenkai and Aviva that if your notice is insufficient for one particular treatment plan, but is sufficient for the rest, that doesn't actually impact your MIG position across the board. It just impacts your denial based on the MIG for that one treatment plan. And that was a major concern when Augustin and Unifund came out. And I think that this Divisional Court case actually confirms that your MIG position isn't affected across the board by one insufficient denial. So moving on to some cases about psychological impairment, I'm going to pass it over to Sonia.
Okay, so when it comes to psychological injury as the basis for removal from the MIG, a formal diagnosis, as in with a DSM disorder, is not technically required. So it's not a statutory requirement. In fact, the LAT has commented recently, for example, in the 2020 decision of Salmon and Certus, that the MIG removal requires a claimant to establish either a psychological condition that meets the threshold for a DSM diagnosis or that substantially impairs their functioning. However, in practice, at least in our own practice, we've never seen a successful MIG removal on the basis of psych injury without a formal diagnosis. That's practically not really successful. We do see that removal on a psych basis is fairly infrequent, but there are two cases from the last year that are worth noting. So the first is Singera and Pembridge, which was released in October 2020. In this case, the claimant was removed from the MIG, but she had diagnoses from both assessors. So her own as well as the insurers, they both diagnosed her with DSM disorders. You might be wondering why the insurer disputed this if both assessors agreed that she met DSM criteria, while the insurer argued that the diagnosis was not caused by the accident, but they were unsuccessful. The next case, which came out very recently, I think within the last month or two, is Jiva Kumaran and Unifund. So here, the claimant's own assessor did diagnose him with an adjustment disorder, but the insurer's expert found there were significant issues with validity and reliability of the results of his own psychometric testing. So as a result, he did not diagnose the claimant. The insurer also argued that there was a lack of corroborating evidence for the diagnosis, but nonetheless, the adjudicator found that the claimant had consistently complained of psychological symptoms. And in this instance, that sufficed to remove him from the MIG. So we don't know exactly what records the claimant produced. We assume that they were primarily family doctor's records, could have been something else. But nonetheless, this removal with heavy weight just on consistency of complaints seems like a bit of an anomaly to us, worth being aware of, however. Also on the topic of corroborating expert reports, another very recent decision, Lotham and Allstate, which came out in late February this year. This just confirms or emphasizes that diagnoses that are uncorroborated by clinical notes will not be as persuasive, obviously. Moreover, a diagnosis which is contradicted by the claimant's clinical notes will not be persuasive in all likelihood. So the adjudicator in this case was very clear in noting that the claimant's assessor did not seem to have reviewed any of his corroborating clinical notes and records at all. And if he had reviewed them, he would have seen that at least 6 months prior to the accident, the applicant had actually stopped complaining about psychological symptoms.
So we wanted to sort of touch on, based on the case law that we've been seeing coming out of the LAT, what kinds of things you should be looking at when you're handling a file. So, I mean, the first thing you should always be thinking about is what evidence does the claimant have? Do you have anything? Did you just get an OCF 18 with a pre-screen? Is that all they're relying on? So you want to make sure you know what they're relying on. And if you don't have any records, you want to make sure you're requesting them under Section 33. When you're looking at a Section 25 psychological report, again, you want to see if what's been diagnosed there is corroborated by other records on file. Are they saying that they can't drive anymore and they've been diagnosed with a driving disorder or a specific phobia, I should say, but yet they drive every day to and from work? That, I would say, is not consistent complaints. And you want to see, there's always usually a list in a report that sort of says documents reviewed by assessor, and you want to see what they've looked at. Because if all they've looked at is an OCF 18 and an OCF 3, then I don't think that that is supported by sufficient evidence. What you want to see is if they've looked at actual clinical notes and records from the family physician or any other treatment provider. Another thing you want to look at is whether they've actually pursued counseling. Because you get a lot of these files where they actually go ahead with getting the Section 25 report, but then they never actually submit an OCF 18 for counseling, or if they do, they never bother attending. And I would suggest that that also is good evidence that the person is not interested in psychological treatment and doesn't have a psychological impairment. But at the end of the day, I really do think that the family physician's records are the most important document that you should be requesting at the very outset of a claim. I recommend doing it by way of a Section 33 request so that you can put them in non-compliance if they don't provide you with the records, because at the end of the day, you probably want to get a Section 44 report, but you don't want to get that report without having any medical evidence available to your assessor. Because if your assessor takes the claimant at their word based on their self-reports, you may end up with someone being diagnosed with a psychological condition when they've never actually complained of any psychological problems to their family physician. So I would say Section 33 requests at the outset, try and get as much information as you can before going to the Section 44, and then you'll be in a really good position to defend your claim if you eventually end up at a hearing. So moving on to chronic pain, I'm going to hand it back to Sonia to talk about some recent cases.
Okay, so this first case is actually not that recent. It's not from the last year. However, YXY and the personal is a 2017 case that continues to be cited in almost every chronic pain case today. It's authority for the requirement that chronic pain needs to be accompanied by functional impairment or disability to justify removal from the MIG. So while the necessity of functional impairment or disability is not a statutory requirement, we see most adjudicators requiring that in order to remove somebody from the MIG based on chronic pain. This case has actually been cited 20 times in the last year alone. So for several years, people were under the impression that a diagnosis of chronic pain, a formal diagnosis, was required, even though that's not in the statute. However, in CG and the Guarantee, which came out in August 2020, the claimant was actually removed from the MIG on the basis of chronic pain without a formal diagnosis. So in this decision, the adjudicator cited the 2018 decision of TS and Aviva, which actually stated that by definition, chronic pain is a condition that persists for 3 to 6 months, or more than 3 to 6 months, and is chronic in nature. That was the executive chair of the LAT actually in TS and Aviva, and he was relying on the American Chronic Pain Association's definition of chronic pain. So TS has actually been referred to not only in CG, but about 12 times in the last year. Still carries some significant weight. What makes CG and the Guarantee different, however, than the other decisions referencing TS is the weight that was given to the duration of the claimant's pain. This seems to have essentially been the determinative factor here. The only evidence was doctor's records indicating multiple pain-related visits, and an OCF3, which anticipated the duration of disability to be more than 12 weeks. It is worth noting here, though, that the claimant was catastrophically impaired in a previous accident. So you do have to wonder if and how much this influenced the decision, if there may have been an element of sympathy in play here as well.
One thing we're actually seeing a lot of at the LAT is references to the AMA guide. So there was that reference to the chronic pain definition, but we've also seen these 6 criteria that are on the slide in front of you. I'm not going to read them out verbatim, but essentially they are used to establish functional impairment. And a person has to meet 3 of these 6 criteria to be considered to have suffered chronic pain. So you can see the first one is essentially abusing prescription or illegal drugs. And the second one is excessive dependence on healthcare providers or family. So that would be if the person is constantly going to the doctor, or if they claim they can't leave the house without some kind of assistance. Next one is secondary physical deconditioning due to fear avoidant behavior. So essentially if there's some muscle wasting or some kind of weakness that they're experiencing. Number 4 is withdrawal from social milieu, such as work. Work seems to be a very big factor in a lot of cases. If someone goes back to work immediately post-accident, typically they're not going to be found to suffer chronic pain. Number 5 is just basically failing to get back to their pre-accident activities. So if they claim to have really loved going to the gym, I feel like everyone always says they loved going to the gym. If they claim they can't go back because of pain, that might be enough to meet that criteria. And number 6 is essentially developing a psychological problem as a result of their pain. So there are some subjective issues here, but the LAT really likes these criteria. They've specifically stated that they're not binding because they're not incorporated by reference into the SABs. However, they've been referred to in multiple recent cases. There's a list there of about 5. I would say that Aviva has really used these criteria a lot. You see them in pretty much every decision that comes out with Aviva being the respondent. But it's being used by other insurers, as you can see there, Unica, Unifund, cooperators. So it's being used a lot. And I also just wanted to point out the 2 cases of Zappia and Unica and Lukash and cooperators, because I found it quite interesting that in both of those cases, it's different adjudicators. It's adjudicator LAT and adjudicator Boyce, who I believe is now a vice chair. But they both reference TS and Aviva as well as the 6 criteria in the AMA guides. And despite TS basically establishing that you just need to have pain for this period of time, they both found that the AMA guides can actually be read harmoniously with TS and Aviva, and both are persuasive in determining whether a person suffers from chronic pain. And essentially that's because in TS and Aviva, the executive chair described pain as causing adverse effects on an individual's well-being. And they say that the 6 criteria in the AMA guides are a useful interpretive tool to determine if an individual's pain is adversely affecting their functional capacity. So it's good to be aware of these criteria, to think about them when you're handling a potential chronic pain file. But essentially what you really want to be looking for in a potential chronic pain case is a credible diagnosis by a specialist. I think that essentially if the person has been to a pain clinic and then been diagnosed with chronic pain syndrome, I don't think you're going to be successful in saying that they don't have chronic pain. You want to also look at for ongoing documented functional impairments, so missed work, limitations in their activities of daily living and social withdrawal, like in those criteria. Again, if someone has gone back to work, particularly if it's a heavy type job, I don't think that they can be successful in a chronic pain claim. Unless perhaps an adjudicator would find that attendance at a chronic pain clinic essentially is sufficient, but I haven't seen that personally. Then there's also a history of treatment geared towards chronic pain. So you want to look and see if they are actually getting injections. Are they on prescription medication? Are they going back for more prescriptions? Are they filling those prescriptions? Those sorts of things. And consistently documented complaints of pain in the family physician's records. You want to see if every time they go, are they complaining of this kind of pain? And also whether the doctor is actually making note of whether it is impairing their functionality or not. Because if they're just writing complaints of pain, that may not be enough to get them over the line. What they need to do is complain of pain and also have some kind of functional impairment based on the case law. So moving on now to concussions, which has also been a bit of a hot topic over the last couple of years at the LAT. I just wanted to sort of briefly mention that there can be some confusion at the start of a claim whether someone actually has a concussion or if it's just whiplash. The reason is that these two injuries actually can occur by the same mechanism of accident, and the symptoms are often very similar. So the person normally has neck pain, headaches, some disorientation, some dizziness, those sorts of things. I haven't actually seen a case at the LAT where they've had to sort of identify whether this person has concussion or whiplash, and I think that at the point that they get it, usually there's been some kind of formal diagnosis, but it is something to keep in mind when you are dealing with a claim at the outset. So I'm going to pass it back to Sonia to talk about some recent concussion cases.
Thanks, Julianne. So the first case that I want to talk about is Jolie Coeur and RBC Insurance. This is one of 3 cases from the last year in which the claimant successfully escaped the MIG on the basis of concussion or head injury. And that was out of 13 MIG concussion disputes or at least that the decisions were released in the last year. So that's about a success rate of 23% on the concussion issue. So in Jolie Coeur, the adjudicator removed the claimant primarily because they had an immediate post-accident diagnosis of not formally of a concussion, but of a head injury. So that's all it said on the diagnosis was head injury / MVA. And the adjudicator opined that while this diagnosis does not use the specific terminology of concussion or a mild traumatic brain injury, because a head injury is not specifically listed in the SAB's definition of minor injury, the MIG does not apply. Pretty straightforward. A little more complicated was PS and Wawanisa. So here the claimant was removed from the MIG on the basis of a concussion, but they did not have a formal concussion diagnosis. Or sorry, they did rather, they did have a formal concussion diagnosis. It was made about 1 month post-accident on the basis of a SCAT-3 test. What was a bit unusual here was that just under a year post-accident, so about 11 months later, they also underwent a CT brain scan, and that showed no evidence of concussion. The LAT decided not to give this any weight, and their comments were that because the claimant had actually submitted some medical articles, journal articles, to support their claim, one of which stated that CT scans cannot show if you have a concussion. So it's hard to say if the claimant had not submitted that secondary source evidence, those journal articles, if the LAT would or would not have given weight to this second scan. Additionally, however, PS did have corroborating evidence. So it was well recorded in his clinical notes and records that he demonstrated symptoms of concussive syndrome. He had ongoing headaches. He had neck and back pain, still at about 10 months after the accident. That certainly helped. Lastly, the third successful concussion claimant was in Davydenko. This was a very recent decision. So this just speaks to the variable weight of diagnoses by different types of health providers. So the adjudicator was very clear here that he preferred the evidence of the applicant's neurologist who had not diagnosed concussion, or sorry, to the family doctor, just because they had more specialized medical training and experience. So we do see also a lot of cases or files where claimants will submit OCF3s that list concussion among their injuries, where the diagnosis is made by a chiropractor. Chiropractors cannot actually diagnose concussions, so that will not be a convincing diagnosis. A family doctor's diagnosis is fairly convincing, but a specialist is always going to be much better, as was clear from this case.
And I just want to mention, I think that you mentioned that this one, they got out of the MIG, they actually didn't.
Yeah, they didn't. Yeah, thank you, Julianne. They actually did not escape the MIG because the neurologist had not diagnosed concussion.
So we just want to touch base on that handling checklist again. It really seems that the initial post-accident medical records are really, really important in a lot of these cases. So you want to make sure you are requesting contemporaneous medical documentation to confirm a head strike or a concussion diagnosis. So you want ambulance call reports, you want emergency records if there are any, you want the records of the family physician. You want to pay attention to references to any kind of concussion type symptoms or prompt referral to diagnostic imaging like a CT or MRI, or whether they've even been referred to a concussion clinic. I think that those types of investigations might convince an adjudicator that the person has a concussion. But also based on that recent case, has it been confirmed by a specialist, by a neurologist? Because the person may go to a neurologist, and when I look at these records, I find the neurologist simply parrots concussion diagnosis made by the family physician. But sometimes they may actually look into it further and say, I actually don't think they have a concussion. So you want to look for that kind of confirmation. And if there's nothing in the file, you may want to consider doing your own investigation. So do you want to do a biomechanical analysis if you're not even sure that the mechanism of accident would have resulted in a head injury or concussion, or get a Section 44 neurological assessment and ask them to specifically comment on whether this person suffered a concussion. And I think that that would be good evidence to use if you are taking the position that there was no concussion. So I know it was a lot of information to throw at everyone in such a short amount of time, but we wanted to make sure we had time for questions. So if you have any questions, please submit them in the Q&A box. Sonia, do we have any?
Yeah, so we have one question for the first question, which is, how do we deal with credibility if most MIG disputes are written hearings?
So credibility, I find, comes down a lot to consistency of complaints. So I think that, I mean, I don't typically always say that someone's non-credible if their complaints aren't supported by other records, but it certainly does come across that way to an adjudicator. I've seen a lot recently that someone will go in and they'll specifically ask for a referral. Sometimes the doctor very helpfully writes in their notes that the person wants the referral at the request of their lawyer. So that, I think, speaks very highly to credibility. Obviously, in terms of testing, validity testing is very highly regarded generally by adjudicators at the LAT, particularly in psych reports. So sometimes it's better, I think, to get a psychological assessment as long as you have the medical documents for the claimant to get a psychological assessment with validity testing as part of the process, because I find that the claimants assessors typically don't ever do any validity testing, or they do it and maybe they don't put it in their report if the person doesn't have valid results. So I think in written hearings, as long as you have a good medical record, or even if the claimant has submitted nothing, those types of things do speak to credibility, and the adjudicator will see that.
Great. I think we have time for one or two more. Second question, how do you think you would best approach a chronic pain case in attempting to persuade an adjudicator that the logic in YXY should be followed instead of, the more simplistic logic in CG? So just to remind everybody, YXY is the case saying that chronicity of pain alone is not enough. The claimant must also have a functional impairment or a disability. And then CG is the decision where chronicity of pain alone seemed to be enough.
I personally put YXY in pretty much all of my written submissions. I think that it is a really pithy way of saying that pain is not enough. And I think YXY has been followed a lot. I think CG is an anomaly. I do agree with Sonia's comments about there being an element of sympathy there. But I think that claimants rarely put in evidence in a written hearing about functional impairment. And I think that's where a lot of them are losing their chronic pain cases, because on the other side, it's very easy to point out, someone's gone back to work. They're saying that, they can still do their personal care. They continue to drive. Like, all of these are ways of sort of establishing that they continue to function normally, and their pain actually isn't impairing them that much. So, I continue to push YXY in all of my my submissions, because I think that it is the right definition of chronic pain. And you can always also rely on the AMA guides as well in your submissions, and then I think you've got a pretty good shot, as long as the other side doesn't have significant good corroborating evidence of functional impairment.
So a few more questions have come in. Just because we're 1 minute away from 1 o'clock and we do want to end on time, we might send you answers by email, I think. Julianne, does that work? We
That's
can
fine.
maybe do,
I
yeah.
just wanted to mention that we do have a couple of upcoming webinars. The first one on April 14th is about how to assess housekeeping damages. So anyone that handles tort files, I think that'll be really, really helpful. And then on May the 5th, we have the coming amendments to Canada's privacy legislation. And that one sounds very interesting as well if you're really into privacy, which I think anyone who works for an insurance company is. But I think we've got time for one more question if you want to.
Okay, sure. So we'll just do these in the order that came in. So diagnosis of a specialist is noted as being persuasive. However, how are you using the evidence that this specialist always has the same diagnosis for every client? Historical evidence.
Oh, so if we're talking about like a Wilderman report, I always sort of look at what he's relied on. So I find that he rarely ever looks at corroborating records. He often does psychological testing that usually I find is in like the mild to minimal range, and then he diagnoses depression and anxiety. So that I find affects the credibility of his decision. At the end of the day, when I'm talking about like credible diagnosis by a specialist, I'm not referring to like a Section 25 specialist. I'm more talking about an OHIP funded program or an OHIP funded specialist. I think those are much more persuasive to an adjudicator. I do think that you can come up with a lot of really good arguments to argue against a Section 25 diagnosis of chronic pain, particularly when it doesn't actually make sense when you look at the claim itself reports and the AMA guides. If you compare them to the AMA guides and sort of look at the history of the file, I think that you have a really good shot at defending against one of those reports. Okay, so we want to thank everyone again for joining us. We hope you found it informative. Feel free to email us any questions. Email us if you'd like a copy of the slides. And everyone have a great day. Stay safe.
Thanks, everyone. Bye.
Bye.